Instead, in 1941, he's appointed to this court. There he is on the far right. Sorry about my angle here. That's where the junior justice stands in the posed photos. You see Harlan Stone here, who is the Chief Justice. He was elevated simultaneously with Jackson's appointment. Jackson was the backfill appointment for the vacancy that had been Stone's seat. And also simultaneously, Senator James Burns of South Carolina was appointed. So in one fell swoop, in the summer of 1941, Franklin Roosevelt has a triple appointment, if you will, on the Supreme Court. And this court doesn't last long because Jimmy Burns hates it. It's a kind of indoor, cerebral, out-of-the-fray work that doesn't suit the temperament of a politician. He's a senator. When he's appointed, he's later a governor of South Carolina. And he's a manager. He's a very good manager. And so he begs to be relieved from duty on the Supreme Court, and Roosevelt grants it and pulls him off and appoints him to manage the domestic economy during the war. That's what Burns' job is. So now you see on the far right, Justice Wiley Rutledge was appointed by FDR to fill that Burns seat, and Jackson has moved up to Associate Justice number 7, seat number 8, if you will, on the Supreme Court. Now this is the 4-year period before Nuremberg. I wish to highlight 3 things in Jackson's judging at the Supreme Court during this time period. The first is a case that is much discussed these days, Wickard versus Filbert. This is an opinion that Jackson writes for the Supreme Court in 1942. It's a case that's argued in his first term. It's drafted, it's complicated, but in the end it's held over and re-argued in the fall of 42 and then decided. The court unanimously upholds Congress's power to enforce production caps on a wheat farmer from Ohio named Roscoe Philbrunn. The Supreme Court did switch the letters in his name, so the case is Wickard versus Filbert. Like many Supreme Court cases, that turns out not to be the litigant's actual name. And what the case was about was the scope of Congress's power under the Commerce Clause, the power to regulate commerce among the states. What Roscoe Philbrunn had done was violate the production quota on wheat in his own little Ohio farm by growing 200 extra bushels that he was using for seed, for animal feed, and for home baking and consumption. He was not taking this additional wheat to market. So he said, this isn't commerce, this isn't interstate, this is, like cutting my toenails in my own home. How does Congress have the power to reach this? And the Supreme Court said, it's right there in the Constitution. And Jackson's opinion explains that interstate commerce is a large realm of activity that includes inactivity in any effect that, when aggregated across lots of small individual steps, of course, is substantial and market affecting. And by Philbrunn not buying his extra wheat in the market, what he's doing is withdrawing demand. His inactivity is causing demand to be less than it would be in the interstate market. That means less support for prices. That means less income for farmers. That means less effectiveness of the AAA as a depression relief statute for farmers. And Jackson writes this opinion, which is the sweepingest, broadest, unanimous Supreme Court articulation of what the framers put in the Constitution with our interstate commerce power. That, of course, was a big issue in the healthcare decision. In the end, it's one that the court somewhat sidesteps. They draw a distinction, we can come back to this in questions, between activity, which Congress's power reaches, and inactivity, which 5 justices, although not in one opinion, said the healthcare law is about. Being uninsured, they said, is inactivity. Well, as Justice Ruth Bader Ginsburg in 2 lines very effectively says, not buying wheat in the interstate market is also inactivity. We read Wickard versus Filbert. And of course she's right. And of course Chief Justice Roberts knows it. In his opinion, because he's a brilliant man and has, I think, intellectual honesty about this, he says, okay, economists understand that the distinction between activity and inactivity is false and artificial. Every act is the flip side of an inactivity event. And then he sort of sidesteps and said, the framers meant to limit the commerce power to activity, with no citations, no historical argument, etc. But that's Wickard versus Filbert. A big decision, a big landmark, a preserved landmark under the healthcare decision in the full range of activity, but not reaching what the court may in the future label as inactivity should Congress ever pass such a law of that type. A second case that Jackson decides, Barnette versus West Virginia State Board of Education. Again, the court spells the name of the parties wrong. This isn't my selection principle, but it just happens that some of Jackson's biggest opinions are misspellings. The Barnette sisters didn't have an E on the end of their name, but they were Jehovah's Witnesses. They did have religious scruples against saluting the flag. They were expelled from school when they refused to salute the flag. Their parents thereby became criminals for not sending their children to the public school as the state law provided. And the Supreme Court just 3 years earlier had held that the government had the power, state governments had the power, to compel patriotism. And that was 1940, the Govitis case. This, goodness sakes, 1943, was now wartime. If the patriotism argument was strong on the eve of war, surely that was going to carry the day in 1943. Well, that triple play of appointments, plus some authentic reconsideration by Justices Black, Douglas, and Murphy, caused the court to change its mind in just 3 years, very directly, and to say that their previous decision was wrong, and that in fact there is a first dimension realm of conscience that entitles one to refuse to obey a compelled orthodoxy. The government may not prescribe what's orthodox in matters of faith, belief, religion. And so the court, Jackson writing for the court, strikes down the expulsion, the convictions, the flag salute in the state of West Virginia, a major liberty landmark in Jackson's pre-Nuremberg judging. The third piece of pre-Nuremberg judging I want to touch on is really sort of a trilogy. These are connected dots. The sequence is a case called Ex Parte Quirin, a case called United States versus Hirabayashi, and a case called United States versus Korematsu. They aren't all about exactly the same thing, but you'll see the executive power thread that connects them. Ex Parte Quirin was a habeas corpus action brought by a very brave Army lawyer who was representing captured Nazi saboteurs, challenging President Roosevelt's creation of a military commission system to adjudicate their guilt in Washington, D.C. in the summer of 1942, when, of course, the federal courts were wide open and doing regular business. By what constitutional power does the President of the United States do this? Have executive tribunals as an alternative to the regular criminal justice system? And Roosevelt's argument is, I'm the president, I can do this. The laws of war are one of the president's powers. And the Supreme Court, in an agonizing opinion, upholds that in the summer of 1942, unanimously, in a special summer session with a verdict rendered by the Supreme Court, and then after the convictions and the executions of 6 of the 8 saboteurs, opinion writing that follows, very awkward and uncomfortable. The Supreme Court says, in wartime, as a function of constitutional language and the international law of war as embodied in U.S. statutes and customs and so forth, the President may set up military commissions of the type that adjudicated the Quirin and companions case. Robert Jackson is the rookie justice. He is the Roosevelt inner circle advisor of the United States. He is not a writer, but behind the scenes, a very uncomfortable, agonizing, concurring reluctantly justice in the Quirin case. There's a great unpublished opinion, as there are in many Jackson cases, because his style of thinking was often to pull out a yellow pad, like I have in front of me, and begin to doodle. And sometimes in the form of an opinion. He'd read a brief and start to write what he thought his position would be. And then he'd start to read the other brief, he'd flip a page, and he'd start to write an opinion the other way. And then he'd flip another page, and he'd try to harmonize his thoughts and work it out and so forth. In the Quirin context, he got pretty far down the line of writing a limiting opinion about executive power, and then in the end, perhaps just deferring to his chief, because collegiality, comedy, and institutional function are values in the Supreme Court, he files it away. Now, 10 years later, that's going to come back, but we'll get to that later.